This is State of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215. Quentin Height appears apparently on his own Zoom. Jaron Regier appears on behalf of the State of Kansas and the Butler County Attorney's Office. For Height, court has an information before it which alleges in count one a charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county.
This is where things start heating up. The judge lays out the charges: interference with law enforcement and failure to register a vehicle. Simple enough, right? But instead of entering a straightforward plea, the defendant veers straight into sovereign citizen territory, challenging filings, nitpicking paperwork, and leaning hard on legal technicalities. And you can already see exactly where this ride is headed.
Both in count two, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions regarding a plea here this afternoon, Mr. Hyde?
Good afternoon. I do not intend to plead. I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety? Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Height. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct.
Notice how he says, "I will be presenting myself." That's straight out of the sovereign playbook. Defendants like this almost always reject both public defenders and private attorneys, convinced only they can properly present themselves in court. But that's a legal minefield. No safety net, no backup. Judges usually give a warning, and you can hear it here. But once the defendant refuses, the court has no choice but to let them go it alone.
Would not be my preference. I would like to have...
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that correct?
I will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one.
I do comprehend this. Thank you.
But you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be presenting myself.
Very well.
Thank you.
This is the heart of the clash. He challenges jurisdiction, demands verified complaints, and points to supposed inconsistencies in the state's documents. Legally, none of this carries weight at a misdemeanor arraignment. The court's only job here is to read the charges and enter a plea. But from a drama standpoint, this is where the sovereign script collides with real procedure, and that's what makes it so fascinating to watch.
The court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this. According to the state's charging document, I'll advise you, Mr. Height, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for that.
I do believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea.
So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
The judge tries to move on, but the defendant keeps circling back, trying to build a record he thinks will protect him on appeal. The problem? Courts don't reward repetition, they reward relevance. What he sees as a safety net usually ends up as self-inflicted damage, because every extra word is one more chance to undercut his own defense.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regards to the case filing. Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
I'm going to assign the case to this division. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Height. It'll be your first appearance with following today's. I want to set the hearing time at 3:00 p.m. You may.
My apologies.
Here's the kicker. He actually moves to dismiss based on corpus delicti, Latin for body of the crime. Sounds impressive, right? But at arraignment, it's meaningless. The state isn't required to prove the entire case yet, just to state the charges. What this really shows is the hallmark of sovereign tactics. Buzzwords over substance.
3:00 Monday, August 25 for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
Okay.
We'll conduct the next appearance by Zoom.
Okay. Is there an opportunity to be in person for any proceedings? And which proceedings would those be?
What we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll be participating by Zoom, but you can participate from the Judicial Center. Make
Okay.
sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3:00. He's going to represent himself. Court has approved and maintained him under his previously established bond of $2,000 cash.
May I also ask what judge?
Okay, just a minute. I'm going to ask the prosecutor. Mr. Regier, is there anything else that we need to address regarding Quentin Height?
Not on this particular matter, Your Honor, although per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's order, stay if the court wishes to address that matter at this time for the purpose.
The judge does what judges do best, keeps it calm, sets the next date, and moves the case forward. But the defendant won't let it go. He starts nitpicking about in-person versus Zoom appearances, demanding details the court doesn't even have yet. It's classic sovereign citizen theater, stalling tactics dressed up to look like procedure.
On that date, Mr. Regier?
That would be the state's presumption, Your Honor.
Okay, and then, of course, you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3:00. I think that concludes our business on
I have one
case at this time.
further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said. You mean in this case that was before the court today?
Correct.
This judge.
The prosecutor drops a bombshell. This isn't the defendant's only case. And suddenly, it's crystal clear why the judge isn't cutting him any slack. When you're juggling multiple charges, wasting time with sovereign citizen theatrics is the worst move you can make. Yet he doubles down, fixating on who's the judge, as if that changes anything. The judge shuts it down cold. This judge is hearing the case. Gavel down, session over. All that noise, all that energy, and for what? The case moves forward exactly like every other.